May I please? I beg to mention for listing of a matrimonial appeal, my lord.
When?
Monday.
May I please, the lordship, I beg to mention one criminal appeal jail, my lord, to come up for admission on Friday, my lord.
Friday?
My lord.
No, Friday we have got DB one also. No time.
Monday. Mass office.
Yeah, please also. My lord, there is an order to file written objection in this appeal item number 15, my lord.
Oh, item number 15, the order is filed an objection. That is, my lord, ready, my lord, can it be taken up next week?
Written objection has to be fair. Huh?
Will file today itself or by tomorrow, my lord. Can it be fixed next week? My lord?
Oh,
My lord, can it be, my lord, second week of March, my lord? Second week of March, my lord.
no problem.
Yes, ma'am.
But paper book has not been made.
Yes.
Item 15.
Yes, ma'am.
Right, Mr. R.R. Kaushik. Learned MP, please submit that he will be filing written objection
By tomorrow.
within 2 days. On the prayer of the parties, list the matter on
Next week of March, my lord.
next week of March. Next week is February. What do you mean next week?
Yes,
of
yes,
March?
I know.
What do you mean next week of March? Tell me.
First week of, yes.
Today is 4th of February.
Yes, ma'am.
Next week will still be February, so it cannot be next week of March.
Yes, yes.
What do you want? Next week or March? Which one do you want?
March, my lord, in the second week of March, my lord.
Say that, not next week. You want it in the second week of March.
Yes, ma'am.
List the matter on the second week of March.
I'm deployed.
As per the prayer of the counsel for the applicant.
No, sir.
Then in the main appeal, you write, as paper book as TCR has arrived, this registry to prepare the paper book.
Deploy blush.
Give a date.
Yes.
May I please, your lord? So I beg to mention item number 17, lord. When the adjournments with kind some accommodation may be given.
Right, on the, why?
So Mr. A.M. Bora is not doing well, lord. So kindly indispose that.
Let me see this matter. Okay, no problem. Right. Adjournment prayer has been made on behalf of Mr. A.M. Bora, learned counsel for the appellant. This is an appeal under this is an appeal against the conviction of the appellant under section 4 of the POCSO Act. Office note also shows that respondent number 2 has been served notice. However, no one appears for the respondent number. Ms. S. Sharma is appointed as the counsel for the respondent. Huh? This is the matter. When?
After 2 weeks, lord.
This is the matter after 2 weeks. Give it. Have you been given a copy of the paper book?
Lordship, we have received.
You received. Mr.
V.A. Chaudhary, lordship.
V.A. Chaudhary appearing for Mr. M. Bora submits that paper book has been received by them. Registry to furnish a copy of the paper book to Ms. S. Sharma, legal counsel.
DP applies.
Madam, you have been
Lordship,
convicted
yes, Lordship,
under 376(1).
one. And these,
The child has been born, not
yes, one.
born. Your child,
Yes.
right? Heard Mr.
You.
U. Chaudhary, learned counsel for the appellant, who submits that the impugned judgment dated
31/3/22.
the impugned judgment dated 31
2000
2018 passed by
2022, your lordship.
huh?
2022.
31/3/22
22.
passed by the court of the special judge
POCSO.
POCSO Kamrup M. Guwahati in sessions case number 256/2018 arising out RAPS case number 329 of 2018, by which the appellant has been convicted under section 4 of
Lord,
the POCSO Act should be set aside.
N 377 IPC.
and 377. Issue notice. No, admit the appeal.
Admit.
Issue notice. Call for the PCR. Issue notice to the respondent. Mr. R. Patrick accepts notice on behalf of the state. Then same thing, huh? That's it. Soft copy.
Lordship. Lordship, there is a IA that is considered.
Okay, Mr. U. Chowdhury's name to be reflected in the file.
Lordship. IA to be considered later, Lordship.
I, Mr. R. Kaushik is granted 4 weeks time to file.
Oblate.
May I please your lordship? My lord, I am also as legal aid counsel, my lord. My lord, in this case, this is an appeal against the judgment and order passed by learned Sisindra Saraidu, my lord, in which case. my
Third,
lord-
Ms. P.B. Borderai will submit that the impugned judgment and order, impugned judgment dated 24/3/23 passed by the Session Judge Charadio in Sessions bracket CHA bracket close case number 23 of 2021. Comma, by which the appellant has been convicted under section 302 IPC. Should be said. Admit the appeal, call for the PCR. Mr. R. Kaushik accept notice on behalf of the state. This is the matter on, give a date. Then in this, you'll say 4 weeks time, huh, in the IA.
I also.
Same.
Is.
Given, filing written of it.
Seven months.
May it please the Lordship. Appeal against acquittal, man.
Yes, why, what is the?
It's a dowry death case, man.
So,
And
what is wrong with the
it
judgment?
was occurred, man, within 3 years of marriage.
So, what is wrong with the judgment?
My lord,
Just because 3 years doesn't, just because it happens within 3 years,
my lord.
doesn't mean that it is proof that it has happened, that.
My lord, the death occurred, my lord, within the campus of the, my lord, in-laws, man. Well, husband was present and there is no direct evidence to that.
What did the learned trial court say?
Trial court says circumstance, my lord, could not be proved by the prosecutor. And the judgment is so
What
perfunctory,
is this? Where is the finding?
my lord,
Where is the finding of the learned trial court?
my. I'm firstly, my lordship, see, my lord, the perfunctoriness of the, my lord, trial court, man. One thing,
I'm asking you, where is the finding? Let us see the finding.
my lord. Page 78, man. In the case at hand, it is seen that PW4, who is the brother of the victim, had averred that the accused deposit during his conjugal life with the deceased has raised demands for money and inflicted physical and mental torture upon the victim. And they had given various sums of money to deceased, but the accused demand kept going about which deceased had informed to him and his parents. He had also averred that he helped the accused in opening a grocery shop in front of his house by arranging goods, constructing a shed, and by giving small amount of cash, and even thereafter accused sent the deceased to their house for bringing money. PW4 also stated that learning about the deceased burn injury when he went to civil hospital, the victim, since deceased, reported to him that she was assaulted by the accused deposit on the previous night and on the morning of the alleged occurrence, and that her parents had aided deposit in his overt act. PW 247, 2, 7, 8, and 9, on the other hand, in the respective areas stated that the accused deposit at the relevant time was at his shop. Shop is by the side of his house, man. Within the same house.
Okay.
With them, when all of
Okay,
them.
so it is not in a far off place. So, okay, no, because
Same house, my lord.
same house.
In the front, my lord, there is a shop.
Okay, in the front there is a shop.
My lord.
And the back side is the house.
Link between the shop and the house. Door you think.
Oh, oh.
And judgment was, my lord, so perfunctorily done. Your lordship kindly praise one sentence, my lord.
Again, where?
Just see, my lord. Page 84, my lord. Just for a moment.
Yes.
Fourth paragraph. my lord.
Yes.
As per section 357A CRPC, victim compensation is permissible under Assam Victim Compensation Scheme. The death of a victim causes loss to her next of kin. But in the instant case, accused is one of legal heir of the victim. Besides the accused person, the victim survived by her parents. There is no evidence on record about the existence of any children. Now, your lordship kindly peruse my lord, page 19. my lord.
Page 90.
Page 19. my lord. Second paragraph of the
I've got no page.
page 19, my lord.
19.
19. Evidence of PW2, paragraph number 2, my lord.
Who is PW2?
One is, says my lord, Joya Borua, my lord.
What is the relationship?
My lord, I'm kindly peruse my lord first, my lord.
Ah.
Second paragraph. Porinita Kolita died within 4 years of her marriage with the accused Devojit. Devojit and Porinita has one daughter, my lord. Judgment says there is no son or children. As on records, my lord. But PW says there is a daughter of the victim, my lord. Thus, my lord, the learned trial court has not applied this judicial mind in my lord, passing this judgment. Everything has been brushed aside, my lord. And the accused, my lord, who are the custodian of the victim at the time of the incident, they have not explained, my lord, how incident was taken place. How the victim got injuries, my lord, in their 313 statement. This is one example, my lord. There is record evidence that the victim had a daughter, my lord. But the judgment says there is no children.
Let us see the place of occurrence. Where's the sketch map?
Sketch map, my lord. Right now I do not have this sketch map.
Because when you come to page 80,
My lord.
last 4 lines.
Yes.
It says here, now it must be understood that if a person chooses to set another person ablaze, he has to remain in proximity with the person who is to be put on fire.
My lord, husband was at the time, allegedly, my lord, he was in the soap, my lord. Soap is by the front of the house. There is a link between the house.
It would not be possible to burn a person by pouring kerosene
Yes.
by remaining at a far off place intervened by many rooms in between. How many rooms are there
My
between?
lord, they are poor people, man. They are demanding money from the brother, my lord, for opening a soap, my lord.
Now, how many rooms are there?
There are only 2 rooms, 2 or 3 rooms. Small room, my lord. Thread's house. And the incident was taken place when the accuser,
Right, that's Mr. P.J. Saikal, learned counsel for the complainant.
my lord. Original complaint father, my lord, he expired, man.
For whom?
He is the brother, my lord.
Who is the brother of the complainant?
Victim, my lord.
Brother of the
of the
victim. Brother of the victim. Challenging the impugned judgment dated 9/9/2024 passed by the Sessions Judge Khipchagar in Sessions case number 244 bracket S-S bracket close of 2015. Arising out of Khipchagar PS case number 868/2014, by which the respondent, no, the respondent number
The responding one, three of them, my lord. My lord, 2, 3, and 4.
2 to 4.
2 to 4.
2 to 4
Yes.
have been acquitted of the charges framed against them.
304.
That is 304
B,
B.
302 and 34.
That 302, that 34 IPC. The appellant's counsel submit that there is a shop at the front of the matrimonial home, and the house is at the is behind the shop. However, the learned trial court, while acquitting the accused person, held that it would not be possible to burn a person by pouring kerosene by remaining at a far off place, intervened by many rooms in between. He submits that the said finding of the learned trial court was incorrect, as the place of occurrence was one room, was in the back, was in the front side of the house, while the shop was in the
Yes.
front side of the house.
Yes. Adjacent room,
Adjacent or back? Adjacent means sideways,
back, my lord.
and you cannot have the shop at the back side of the house.
Yes, at the front, my lord.
He admit the appeal, call for the TCR, issue notice. Returnable in 4 weeks. Mr. Arak Kaushik accepts notice on behalf of the state. Appellant to take steps for service of notice by speed post. Or response number 2 to 4. This is the matter. We will-
All right.
Heard Mr.
May I please, NH Lordship.
NH Justice Senate Counsel for the appellant, who submits that the appellant has been convicted under section 363 IPC and section 4 of the POCSO Act. By judgment dated 10/10/25 passed by the special judge bracket POCSO, Kachar, in special bracket POCSO case number 208 of 2024, arising out of Udhar Bond case number 57 2020. Admit the appeal. Call for the TCR. Mr. R.R. To notice returnable in 4 weeks. Mr. R.R. Kaushik accepts notice on behalf of the state. Appellant shall serve soft copy of the appeal to the appeal.
Yes, Lordship, here is an IA Lordship. It may be considered after receipt of the.
Then, in the IA, right, Mr. R.R. Kaushik, 4 weeks.
IA here Lordship, it may be considered. I know.
He has got to file an objection.
Yes.
Before that, you give him a soft copy of the appeal. Soft copy of the appeal. That has to be given to the IO.
Yes.
I mean, not IO, OC.
Yes. I know.
Six order. Please, my lords. That was on the last day. Lordships had called for the service report again because after the first day, Millers, after the OC had been asked to serve the notice, a service report had not come. Till now, Millers, there is no office note on that. The LCR has come.
I'll take extraction, my lord, tomorrow or any date, my lord.
Right. Mr.
He got them.
Ray Gautam appears for the appellant. Mr. R. Kaushik submits that he has not been given any report with regard to service of notice on the respondent number 2. The matter pertains to conviction under section 6 of the POCSO Act. As the PCR has arrived, registry to prepare the paperwork. On considering the fact that there has been no report with regard to service of notice upon the respondent number 2. This court appoints Miss M.K. Brown. M.K. Brown, legal aid counsel,
Am I?
legal aid counsel, as counsel for the respondent number 2.
Am I?
Am I clear? Okay, appointed as a Michael Scurry for respondent number 2. This is the matter after. Give it date. Under 4 weeks. Because some time will be taken, no?
That much. Very well. Great.
Please, your lordship. Lordship, the report upon service, report regarding service of notice is still awaited.
What is your name, ma'am?
C. Kalita.
C. Kalita. Miss C. Kalita appears on the record. There is no return of. There is nothing to show that notice has been served upon the respondent. As PCR has arrived, registered to prepare the paper. Nothing has happened, 1 year has passed. Yeah. We'll appoint MP Brown again. Give us some time. As no one appears for the response number 2, even though office note indicates that. Office note, indicates that. Notice for the response number 2 had been furnished to the learned AP on 5/2/2025. Accordingly, make that brown again.
Apply, Your Worship.
My lord, kindly see order dated 28/5, my lord. We have given the translated copy of that is on the record.
28/5,
Yes.
2025.
28/5, my lord. Okay.
With regard to the IA.
Yeah, I am. My lord, comparison, one comparison is there, my lord. And list of dates also, this one. my lord. That is already on the record, my lord.
Oh, paper book has not been made.
No, no. We have, my lord, because we made it clear that we will give the translated copy of the deposition.
So you want to have the IA?
I am, my lord.
IA. Yes.
Yes. Now kindly see my lord FIR, page 1 to page 1. The compilation, man.
Yes.
The lordship will find that is FIR is 21/6/16.
My lord, in this case, my lord, all the state has been filed, my lord. Affidavit has been filed.
Okay. So you all have given your affidavit. Now, basically, I think the Supreme Court wanted that each state government should have a policy.
Policy, they have to, first they have to policy, they adopt a policy, then they implement it.
Right.
That is done. And this honorable court only to monitor.
Correct. Now the affidavit, I think Assam does not have a policy.
No, we have prepared a draft cabinet memorandum.
Draft. Do you have a policy?
Amend and modification policies. This is my affidavit says the draft
You already have a policy, every amending it.
amending. We have policies.
We are amending it. Now, Mizoram,
We have already incorporated
Yes.
some changes in the police manual, Lordship, job police manual.
for remission.
Yes, Lordship, that is, I have already incorporated, Lordship, and next one, I have, that not, I have.
Paragraph
What
5.
about you, Arunachal?
Lordship, our mental manual, Lordship. That is the chapter on solution and election. After the Supreme Court order, we have this.
That you have not mentioned in your affidavit. You have mentioned the number of prisoners. Okay. And that is for which period? The period, when did you release them on remission? When is the last one?
From 9 months, 26.
9 or 26, okay. Okay, then it's good. What about you, Nagaland?
Yes.
Have you released anyone?
Yes.
How? So what we expect, we will record all this. What we expect from all the states is to give an affidavit stating as to who has been released on remission for the last maybe 5 years
With data.
with data. Last 5 years and the dates, everything. Last 5 years, okay. So that once we give that, then
My lord.
then basically we are done for the.
No, basically, my lord, all the state have, but there is a policy and down they are going to some amendment also going to be
Yes.
made, my lord.
Yeah.
And in fact, in the case of Arunachal Pradesh, the committee is also formed, my lord. So now my progress has been done. But your lordship now wanted to, my lord, know that how many persons are already been released in remission
Correct.
and with full datas.
Correct.
These are their period and these are.
Cannot be for the last from say 2021 onwards,
Excuse me.
2020 onwards. Let us know how many.
2021, we have started.
Or 2021. Okay, we'll take it from 2021. What about Nagaland? From when did you start releasing? Yeah, from 2021 you start. We'll make 2021 the standard. You give the number. And another thing on that score, what we would like is as on January 26, how many convicted prisoners you have in each of the jails within your state? Now, Arunachal, you've got one jail.
We have both lordship, 2 district jails, lordship, there is no central jail in Arunachal.
So you have got 2 district jails. Huh? So in the 2 district jails, the name of the 2 district jails, and the number of convicted, not under trial, the number of convicted persons who are there as on 31st January 2026. Just give us that.
Smile.
As the Arunachal, the prisoners are convicted, some of them are there in Assam also, Assam central jail.
Okay. So you can clarify
Also.
that that these 2 district jails have this many persons, but some other persons, so and so, who are convicted of these cases, in these cases, have been sent to Soweto. Just give us that list. Once that list is there, then we can figure out, what is the rate of remission
My lord.
given to your.
Remissions are a certain procedure, my lord. And that has to hit, that is because your lordship kindly see, actually it was from one cases, my lord, then randomly government released in remission. But remission, before giving remission, they have to take a permission from the court where that conviction was affirmed, my lord. So that procedure has to be followed, my lord.
No, we'll see that.
My lord.
Okay, so then we can also ask them in their affidavit, when you write down the number of persons who have been given remission, please also give the
Details of that.
permission granted by the convicting court for remission of those persons who have been released on remission. And once that is there, I think basically this thing can be closed. for-
Actually, yes, no. So that the government, my lord, from their SOMRO, they
Yes.
cannot do it.
Because
That is the
that
motto.
is the only thing left, nothing more. If not done, you'll have to take steps as fast. So we can, if you give the affidavit, we can basically close this, I think, in a way. Not exactly close, but
My lord. No, that's only monitoring, my lord. Let them, my lord, yes, work out, my lord, and that
Give you
details
time.
data.
will you, how much time do you need? 1 month?
1 month
1 month is enough, I think.
maybe short, my lord, let it be 3 months.
Oh my God.
Please, we have so many jail, we have to collect all
I
and
think so, I don't think.
yeah, too much.
You all don't, revision, you are hardly
It's
released.
too much, Lordship.
1 month will be
Too
good.
much will be reasonable.
Right. I heard Mr. T.J. Mahanta, learned senior counsel, the petitioner. Also heard Ms. P. Bhattacharya, learned additional advocate general for the state of Mizoram. Ms. T. Crow for the learned additional advocate general for the state of Nagaland. Mr. Chandran, learned senior government advocate for the state of Arunachal Pradesh. And Mr.
Mr. R.K. Bora. R.K. Bora.
Okay. And Mr. R.K. Bora, the additional senior government advocate. Additional senior government advocate
Next thing is go to Kuntai.
for the state of Assam. The present so motu is for monitoring and supervising the implementation of remission and premature release policy of the state of Assam, Nagaland, Mizoram and Arunachal Pradesh. In compliance with the orders dated 25 for 2025 and 4/11/2025 issued by the Honorable Supreme Court in the case of SMWP criminal number 4 of 2021 and SLP bracket criminal number 529 of 2020. This is in the order dated 10/12/2020. 10/12/2020. Then the next para in the Supreme Court. In this para, the Supreme Court had directed that where there was a policy of the government laying down guidelines for consideration for the grant of premature release under section 432 CRPC or section 473 BNSS. It was the obligation of the appropriate government to consider cases of all convicts for grant of premature release. As and when they became eligible for consideration in terms of the policy. It also held that it was not necessary for the convict or his relatives to make a specific application for grant of permanent remission. It also held that when the jail manual or any other departmental instruction issued by the government contains such policy guideline, the aforesaid direction would apply. It thus directed states and union territories to formulate a policy for remission if the same was not available with them. Yes, sir. The councils for the parties submit that. No, on perusing the record, we find that all the 4 states under the Guwahati High Court have submitted affidavit. Wherein it is seen that all the 4 states have policies that guideline for grant of remission. However, amendments are being made in the remission policy / guideline applicable to the state of Assam and Arunachal Pradesh. State of Assam. And Nagaland. And Nagaland. Ms. P. Bhattacharya submits that necessary changes to needed changes / amendments been made to the Mizoram
Pension manual 2017.
pension manual,
Prison manual 2017.
prison manual 2017 with regard to the grant of remission. Mr. A. Chandra, Leonard Council for the State of Arunachal Pradesh submits that submit that though there is a chapter in the Arunachal Pradesh prison manual for grant of remission, necessary guidelines have further been have been published in four notifications supplementing the remission policy provided in the said manual. Correct? As required in terms of the Supreme Court's direction. Next paragraph. As can be seen from the affidavits filed by all the four states and the submissions made by the council for the party, the remission policy for all the four states is available while some are undergoing amendments / modification. The above being said, we are of the view that the states should submit further affidavit stating number one, convicted persons in each of the jails in all the jails of each state, and the charge under which and the section of law under which they have been convicted. Number two, the number of convicted persons that have been granted remission in each state from January 2021 till date. That first one was, just read the first one. As on 31st January 2026. Then number three will be, what is the number three? That's all, no?
I think I think that will be happening.
So, list the matter on, give a date. Okay, it's in item one, in that number one, you just carry it after full stop. In respect of the state of Arunachal, we have been informed that some of the convicted persons have been kept in jails in the state of Assam, as in the central jail Assam. Where? Central jail where?
Sometimes they actually
Say Assam, in the jails of Assam, in as much as there are only 3 district jails in the entire state of Arunachal.
not adequate, yes.
So accordingly, Arunachal Pradesh, the affidavit submitted by the Arunachal Pradesh should contain the names and the concerned sections with respect to all those convicted by the courts in Arunachal Pradesh.
Well,
And who are undergoing their sentences in Assam also.
deeply.
Anything.
Second. 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 Deep blue.
Please file it. It's a video very long, sir. Please file it.
May I please, Your Lordship? Lordship, this array has been filed for condonation of delay of 138 days in filing the connected criminal appeal against conviction. Lordship. I am acting as a legal aid counsel in this matter.
Yes, no objection, I think.
The notice was issued to the other side.
Other side has appeared.
Huh?
Notice was issued to the other side. Yes.
Mr. U. Chaudhary, learned legal aid counsel for the applicant. The delay of 138 days in filing the appeal against the applicant's conviction under section
Section 9.
4 of the
P.
POCSO.
Buyan, additional people. And Mr.
R.L. Supriya.
R.H. Sutia, for the respondent number 2, submit as a no objection to the delay
Document of symptoms of either of them filed. Already filed.
of the cause for the
Already
party
delay नहीं already.
and the reasons for the delay.
Already.
Somehow we find that sufficient cause for the delay has been made out.
This one, Diana.
138 days condoned. Registry to list the appeal.
Obligation. Delivery code is what?
Filing numbers. Filing.
Wait, please, Your Lordship. Your Lordship, my senior is on legs at court number 1, Your Lordship. Kindly pass over for the time being.
What is the case about?
This is a 302, Your Lordship.
That much we know. Any eyewitness, madam? Any
Yes,
eyewitness?
yes, Your Lordship.
There is.
Yes, Your Lordship.
Then where do you stand?
Lordship, I don't know. I
No,
don't think I should.
you gotta help us before a senior comes. We'll ask a senior also. So they are eyewitnesses to the crime.
But there are contradictions in the statements, Your Lordship.
Contradicting the statement of?
Regarding the place of occurrence,
Yeah, please.
yes, Your Lordship.
Right, where is the contradiction? Where did it occur?
Your Lordship, it would be better if my
No,
senior-
yeah. We want to hear you. We don't want to hear your senior.
I don't think that would be justified for the.
Then we will hear your senior. You are going to lay the groundwork for him. We don't waste too much time. Yes. So where is the contradiction?
The PW1 has stated that
PW1 has stated what? So PW1 is a witness.
Yes, Your Lordship.
It happened, he saw it from the riverside.
Yes, Your Lordship. Ainuddin fell down on the ground, so Sobahan by means of the knife stepped on the right side of the belly of Ainuddin wrote here. It's a typographical error. Tahir Ali was tightly holding the neck of Siddiq Ali. Siddiq Ali had fallen down on the ground and then he had seen Sobahan armed with the dagger was running after me. I was saved at the timely intervention of Ajibor and Saddam, who had intervened and removed the dagger from the hands of Soban. I had taken both injured persons, Ainuddin and Siddiq Ali, to Dhubri Civil Hospital. Ainuddin had undergone treatment at Civil Hospital. Siddiq had to be shifted to GMC since his condition was serious. Siddiq succumbed to his injuries after 3 days stay at the GMC, Your Lordship.
So who is the appellant here? Soban.
Sobahan.
Sobahan Ali.
Soban. Shahaban. Huh? Sobahan. You say
Sobahan.
BA.
Yes, sir.
Well, spelling out is BA. BHA. Okay. So the Shobahan is seen stabbing this disease.
Written as Shoban. Yes, Your Lordship.
So
Actual just says Sobahan, Sobahan.
HAN,
Yes, Your
Shoban,
Lordship.
Shobahan.
Yes, Your Lordship.
What is it? There's no BA. BA.
So.
Acha, okay.
Shoban,
Oh.
was Shobanu লিখিছে, Shoban.
But in the evidence anyway.
Yes.
Okay, so Shobahan had stabbed this disease. That's all. Now, where is the contradiction?
Your Lordship, for that I'll have to go deeper and.
You have to go deeper. Naturally, we are waiting for you to go deeper. How will we decide the matter?
That is why it would be better if my senior comes and do the math.
Okay.
He's in court one, Your Lordship.
He's on his legs.
Yes.
PW1, there are 4 more eyewitnesses.
And what happened to the other accused persons?
গোটেইকেইটা
কেইটামান একুৰেচি আৰু বেল আছে লৈ গৈছে মই কিবা ব্ৰিফ কৰিছিল মানে eyewitness to 1, 2, 3, 4, 5 লৈকে eyewitness বুলি কৈছে PW6 5 eyewitnesses.
Yes, my lord.
According to the
Altogether, there are 5 accused persons.
My lord,
Correct.
yes.
Huh? There are 5 accused persons.
yes.
And only Sohaban has been convicted under 302.
Yes, sir.
And that Sorab Ali Mola, he has been convicted under 323.
Yes.
Others are all acquitted.
Yes, sir.
Mm. Only 2 are convicted.
Also, PWs are related, Your Lordship.
Okay.
They're relatives. Nature.
Okay, I'm not on that.
Yes.
Now, what has happened to this Sorab Ali Mola? Did he file did he go in appeal? Probably not, because he was only required to pay a fine of 1,000.
Yes.
So he did not file an appeal, I think.
Hmm.
So so it does not matter how we decide the case, the appeal, because it will not affect any other person.
Yes.
So your senior has a job cut out for him. He's got to demolish the evidence of the four eyewitnesses.
Here, Your Lordship, in PW2 and 3 has stated, although they are eyewitnesses and they are the neighbor and cousin of the victim, Your Lordship.
So
And according to the postmortem report, it is revealed that the deceased has sustained 3 injuries, but they have stated that they have the appellant had inflicted a single stab to the abdomen, Your Lordship.
so
And that injury was not fatal according to the postmortem report. Your Lordship. That's why.
then what did he die of? What did the deceased die of?
Hemorrhage, Your Lordship.
Hemorrhage
After
caused by what?
40s,
Hemorrhage caused by that stabbing on the belly only.
Your Lordship.
Cannot be. Is there any? Let us see the medical report. Where is that? Medical.
PM is at 96.
96. That will throw light.
Is 97 is the whose position and character.
97. Stab wound.
Punctured is also there on peritoneum, page 99.
In front of abdomen, back of abdomen. How many witnesses? Eyewitnesses?
How many lordship? PW 2, 3, 4, 5.
2, 3, 4, 5. 4 witnesses.
No, 1, 2, 3, 4, 5.
1, 5 eyewitnesses.
Yes. According to me.
I will wait for your senior.
In this case,
How many altogether? How many appellant?
Total 6.
6 my lord, I represent 3.
I represent.
Give me a big paper.
Hello, can I? Daroga Ali, Saiful and Inzamamul Khan, probably represented by you.
No, you are in which case?
I'm 18, item 18 my lord.
Item eight.
Criminal appeal to plead.
Criminal
Criminal appeal. Mock appeal.
413.
Daroga Ali is 413. We are in 4. I'm in 464.
Only 464.
I'm appearing in 464, my lord.
464, they how many? 2.
2, my lord.
2.
Bacha.
Bacha and Faridul. And one is Lal Mohammed Khan.
Lal Mahmud and Lal Muhammad, represented by Mr. Anshuman Goran.
That
is item number 19, lordship. Criminal appeal number 421. Only.
They are in jail, all of them.
Yes. No, one is on bail, my lord. Lal Mahmud Khan. Mr. Bora's client is on bail. 421 is on bail. Bail order dated 15/5/2020.
So that was short synopsis was given. You know?
Huh?
I think that is not my lord has taken.
This notice by whom?
Not is given by me.
Huh?
This was the,
By you.
my lord, this is only the short synopsis of the entire matter and the findings of the trial court on the different my lord, points, my lord. And the case laws and the witnesses relied on, I have given those things.
Only those questions which are in your favor.
No, no, not mine. I have given everything. I will argue everything, my lord. It's not question of favor, my lord. Here the case is, my lord, we were convicted under section 323, 354, 385 and section 302, 120B.
All of yours convicted under the same section.
Same.
All same section.
And my lord, so far
Just
the
a
my lord,
minute. Convicted under 302, 120B,
then my lord, 323,
385.
323, 354,
54,
385.
85.
So far the, except 302, my lord, the sentence which has been, my lord, we have already served. We are already in jail, my lord. Stay.
How long?
My lord,
14/9/23, my lord. From the date of arrestment.
date of arrest, city has been.
I'm giving.
Date of arrest.
Yes, ma'am. 18/4/22, I believe.
18/4/2022.
18/4/22. Date of arrest.
Yes.
All except for date of, so except for this, Lal Mahmud Khan.
Lal Mahmud was recently given the bail bond. Lal Mahmud is a non-bail.
Bal Mahmud was granted bail on 15/5/24.
For nearly 2 years.
Now, my lord, 32 witnesses were examined. But my lord, so far 302 is concerned. My lord, no eyewitness is there. And my lord, we have been convicted on the basis of the circumstances under section 27, recovery of articles.
27 of
Evidence Act, my lord.
recovery of what article?
My lord,
Recovery of what article?
recovery one stick, small pieces of, my lord, bricks.
What do you mean? One stick and brick.
Any blood stain?
My lord,
Any blood there?
No.
and my lord, so far the evidence is concerned, subject to what my red friend VP says. There is only slapping and all that. No, nothing, no evidence that some with the big bats and all that we have killed them, or with the stick we have hit them. No evidence to that. Now, if you Lordship kindly come to the FIR first.
Very far.
Well, the first information report was lodged on 17/4/2022. At page 4, my lord, page 4 and 5. Occurrence took place on 16/4, 16/4. Now they said about 2:30 p.m. During daytime. Now, may I just read, my lord? I have the honor to state that there has been a love affair between Rabul Haq Chaudhary, son of my uncle, Sokat Ali, and Ramana Khatun, daughter of Kalamia village, so and so, around 12:30 p.m. on 16/4/2022. My cousin Rabul Haq Chaudhary left his home with his own Yamaha bike bearing registration number so and so for village Mandli Reserve to meet his girlfriend Ramana Khatun. Around 2:30 p.m. while both were talking on the bank of river Brahmaputra at village Mandli, Reserve, the aforesaid accused persons detained the duo in furtherance of their conspiracy and assaulted both of them. Upon questioning Ramana Khatun, we have come to learn that the accused persons sent the girl away and asked for money from my cousin, saying that they would hold a bichar and that as my cousin could not pay them money, they had killed my cousin and threw his dead body into river Brahmaputra. Some more accused may be associated with the aforementioned accused persons. Now, my lord, he is not a eyewitness, my lord. He lost the affair after
Informant is PW?
this informant is PW, my lord. PW 5.
He's the
Informant is the cousin brother of the
Cousin.
deceased Rubul Haq Chaudhary.
Okay.
FIR is exhibit marked as exhibit 5.
And my lord, the investigation is started. Investigation is started on the basis of the information given by Lal Mahmood, who is an accused here, my lord. On the basis of,
information given by Lal Mahmood to whom?
my lord, to police, that a boy has jumped. My lord, exhibit P24, the GD entry. GD entry number 233 dated 16/4/2022. Exhibit P24, page 733 of volume 3, my lord. May I take first to my lord to that? 733, no? May I read first that, no? Then I'll proceed through. And Ramana has been, she has been examined as PW1. Page 733. 2:30 p.m.
About 33?
Volume 3, my lord.
Yeah.
May I read, my lord? This entry was made at around 2:30 p.m. Now a person by the name of Lal Mahmood Khan of village Bandali Reserve makes a phone call from phone number Itna to phone number Itna of UBC 335 Alha Khandakar, informing that a boy has committed suicide by jumping into river Brahmaputra at village Bandali Reserve and the police along with SDRF should go to the spot. Accordingly, I, SI Rajiv Neuk, so and so along with first so and so have left for the place of occurrence at village Bandali Reserve. SI Pramod Chandra Krita remains in charge of the diary. The entry has been made accordingly. So the entire investigation is started thereafter. And the trial court has given a finding that, my lord, since that affair is hit by section 162 because that is not first in time.
Yes.
Now, my lord, may I take to PW1?
But this is, he's one of the accused.
He was made an accused, my lord. I'll come to that aspect of the matter, my lord.
But the information was given by him.
And on the basis of that, my lord, the entire police started, my lord, taking necessary steps and all that. After this arrest and all that, my lord, my lord, may I come to the evidence of Ramana Khatun at PW1.
Page,
page 11. Volume 1. She was the girl mirror, she was with the deceased.
girl meaning she's the girlfriend or whatever.
Girlfriend. Girlfriend, and there is an evidence, that they were supposed to be got married at a later stage of time and all that. Anyway, I do not know the informant. I knew this is Rubul Haq Chaudhary, who was my lover. I know all the accused persons. The occurrence took place on 16/4/2022 at about 12 o'clock in daytime. The place of the occurrence is the bank of river Brahmaputra at Bandali. My marriage with deceased Rubul was fixed by our family and we were waiting for attaining the age of majority. On the day of occurrence, the deceased Rubul Haq called me to meet him near the river bank at Bandali. There was a bihita, a raised land on an abandoned house. Bitha. I accompanied by my sister Bimola Khatun. She is PW2. And friend Tasmina alias Josna. She is PW15. Tasmina and Bimola were at a distance and seeing accused Injamul. Injamul हम लोग का है ना. There Tasmina returned. Bimola was standing at a distance from Bitha. Rubul was already in the Bitha and I went there and I was conversing with him. At that time, accused Injamul, Darogali and Saiful started assaulting Rubul for no reason. They had punched the deceased. They had fractured the hand of Rubul. They had also punched me in the face and pulled me by hair. They had also pressed my neck. So, my lord, your lordship will find from here that recovery part I am just my lord, trying to make out, my lord, that nothing has been done with the big bets, nothing has been done with the lathi. So, my lord, the recovery of something which has no link with the, my lord, assault and all that, my lord, cannot take into consideration. That section 27, you know, that discovery, no. Rather, it falsifies the, my lord, prosecution case. हाथ भेंगे नहीं. Well, may I proceed, my lord? Para 5. Injamal, Darog and Saiful used to love me.
We'll take it up as truth.
Yes, ma'am. Yes, ma'am. My lord is not feeling well, seems to be.
No. I'm sitting all right. That I think getting hot. It's getting hotter, I think.
Anyway, lord,
Another batch, my lord, 2 o'clock of fellowship. Or call just.
That's the judgment. They'll take-
Long em there.
We do not find any ground to set aside Rule 4 of the CADC Amendment Rules 2003.
Dismiss. I will launch.
Yes.
How long will you take?
At least to place the materials, my lord, 1 hour, then the case close if need be, then 1 hour to 1 hour.
1 hour for everything.
I'll try to complete, my lord, because some witnesses are not relevant at all. So I'll not read those. The 32 witnesses are there. Your lordship is sitting tomorrow also, my lord.
We are sitting tomorrow, but
Day after tomorrow, I think your lordship not,
Yeah,
day
DB
after, and
one.
thereafter on Saturday, your lordship not sitting.
more than that, we have got one slight problem. We have got some problems till 12. After 12, we don't have a problem.
Tomorrow.
No, no, till 12, sir. After
Oh, yeah, oh, I see. Till
So,
12.
you see, for matters which are going to take a long time to finish, for which are short matters, that we can decide, that's not an issue. But to keep it part-heard and whatnot will be a problem. If it's going to be completed, it should be completed at one go. That's what we think.
But this matter probably going to take some time.
Yeah, so I know there are three appeals and 3 different councils. Senior
My
councils.
lord, so far the facts are concerned, if I
Yes.
place, I think covers all. Their submission they will make. I do not know what, but I'll place the entire facts. Because the prosecution case, my lord, is that, my lord, that they said that I have killed, or we killed the person. My lord, with due respect, my lord, I have not
No,
found
no,
any.
it's all right, it's all right, it's all right. You see, while giving the gist of the case, you can finish it in 5 minutes.
Yeah.
But once you start reading the evidence,
No, Lord,
you're not going to finish it.
no, Lord, I have to read because my lord has to
That is
look
what
into
that's
it.
what we're saying.
Because ultimately, my lord has to write the judgment, my lord. I
Correct,
don't-
correct. We have to write the judgment.
Yes, my lord. Yeah, I have to point out.
On a fair assumption that you are not going to finish
Satara ko rakha.
your submissions within an hour, I'm quite sure. It will take at least 1.5 to 2 hours, I think. Fair assessment of the time. है ना?
Yes.
2 hours, so I think it'll take.
At least minimum 1 hour, so there is nothing. That will be taken because I have to.
We don't want to put it part-heard. That's the only thing. Because this type of long matters, I mean, 32 witnesses, we want to do it at one go.
Can it be on 17th then? Since my lord saying that 12 till 12 is my lord difficult. Lordship is sitting because from the week 23rd onwards, my lord, I'll be away.
17th, we are having some fixed matter. 19th
19th,
is relatively free. That's what we are.
yes, 19th I can, my lord. There is no difficult.
Number 9.
It's not a big matter.
हम उसके बाद नहीं है.
GST matter.
बारह को ना डिफिकल्टी है. 12 को तो हम कर सकते हैं. 12 your lordship.
Not
12
here.
is what?
Next week. And next week I'm not here.
Because my lord, from 23rd onwards, I'll be not there, my lord.
Oh. That we have got to. That'll take time.
Yeah, March में हम एकदम वहाँ उधर हैं.
No. We will not. We will.
March also. We saw this.
Because
They were the good, actually, better.
you see, I think on a fair assessment, probably everyone will
Everyone, yes.
finish in 2 days.
Yes.
1 day, I don't think you all will.
2 days.
2 days, I think you all will find.
2 days.
Because though we might give you a time, but you are not going to adhere to that timetable.
Well, difficult sometimes.
Because
Because I have to pinpoint, my lord, everything to my lord.
correct.
19 and 20. 19 and 20.
19th, 17th and 19th, we have already fixed. Very,
Oh. Yes, madam.
18th हम नहीं सकेंगे.
There was also lengthy matter.
Yes.
16, 18 I'll be not.
28, 21st walking niki.
22 के लिए ले लो भाई.
Saturday. Third Saturday hobo.
কি করে?
No, no, that third Saturday is Eid or something like that. No,
So Ramadan will start, your lordship.
something, there is something,
Oh,
there is some national holiday.
oh.
21st, that's what,
20th and
we are
21st.
on March, no?
No, February.
Are you talking this February? Okay.
Yes,
20th February and 21st,
yes.
20 Milord.
Saturday te khula hobo na nai.
Oh, we have got, you see, we write our judgments on Saturday.
Yes, yes.
We are not going to,
Not as per your lordship's convenience, I may have some difficulty, Milord, your lordship can fix the matter. Because Milord, I'll be
24th, 23rd, 24th,
24, I'll be not there, Milord. I'll be in the Arunachal Pradesh, Milord.
25th.
Entire week,
You'll be there.
entire week I have kept hearing matter of land acquisition, Milord.
That is more lucrative.
No, not lucrative, Milord. I am appealing for NIPCO, Milord. I am appealing for NIPCO. 500 crore extra award has been given, Milord. So that has been challenged, Milord. Milord, I do not know. It may finish in one day also. It may not also be taken up on that day, and I may come up, Milord, your lordship may fix it.
No, 5th and 6th, we are having DB1.
It might have been over.
That is Tuesday. Monday pura start kule well, sir. 9th March of I think jodi start hoy. 9th March section of khali ase khali.
10th to khali ho jaga.
9th and 10th.
9th and
9th and 10th.
Okay, 9th.
9th is Monday, so we'll start.
Oh, yeah.
We'll start on 9th. We get completed probably at
32 witnesses will not be required, Milord. Hardly, Milord, 10 to 12 witnesses are just people. Milord, rest are, Milord, some are already
We
declared.
we don't know. Once you start, so we know we have noticed. And then I'm telling you one thing is that though you will go through the witnesses, the others will again go through witnesses. How?
Milord,
You will go through witness P1, P2, P3. Their other colleagues will also go through them. Maybe not in so much detail, but they will go through them. It happens.
No, it happens, Milord. It happens, Milord. Milord, we can.
Okay, right.
Milord, can it be, Milord, first item of the hearing?
On Monday, there's no hearing. Even if there'll be only 1 or 2 hearings, we don't know. On the where of the council for the party list the matter on 10th,
9th month.
9th March.
From the side of the app. Oh, okay. It will be from the side.
9th March.
Yes, Mr. Kamar, are you okay with 9th March? Because you all are not going to complete today this matter.
But we will have completed it.
Huh?
All prepared our written synopsis notes.
But you all agreed he's going to take us through it then.
Oh, he doesn't know shortcut now. We know that shortcut tricks.
I don't know. You all say shortcut, but once you all start, you all don't know when to stop.
Milord, because if I start doing shortcut, my lord may feel that the other witnesses let it see, Milord, because it's normal.
Shortcut in criminal.
Anyway.
Yeah, we'll do it up now. March or did na? March or
9th of March.
1 month. March of like.
What is this, madam?
Yes. May I please the lordship? This criminal appeal from jail, my lord. It is a judgment and order passed by the.
Whether it is,
We can do it
whether
together now.
whether it is
One hour.
correct, like whether the injury was how the medical evidence has said, we have all have to correlate it there because.
Correlated.
Ah.
It is all in the abdomen. There
Yeah.
are 3 stab wounds in the abdomen.
And I have to see what was the description given by the eyewitness and then.
See here, it says here, stabbed on the right side of the belly by PW1. Then PW2 says on the right side of his stomach.
But it appears, my lord, that there was a cross case also.
In the cross case also, there was allegation and
Definitely.
they are giving only the injury which they had sustained. Because there is one IT, as far as I remember, it was a public place, but only the family members had deposed.
You see, then all these facts
Hmm. And your lordship has also to see who were the aggressor in this case.
No, no. When a person has died,
Yes, yes, nobody is disputing, but whether it is murder or it was a not intention to kill him, it was a fight between them due to some dispute, that will be a mitigating factor to reduce the sentence. That's why your lordship, since the man is in custody, I will
you
also.
see one thing, Mr. Pawar.
Yes,
If
my
you
lord.
look at the last order,
Yes, my lord.
no further adjournment will be given on any ground.
Yes, my lord.
In the event of any adjournment being asked for, this court may appoint a legal aid counsel
Hmm.
for disposal of the case on the basis of the paper book already prepared.
Yes.
We cannot adjourn this. This court has already on 6/1.
No, I'm not seeking any further adjournment, only an accommodation till Monday next month.
No, you see, Mr. Counsel, on any ground, we have said.
No, any ground.
And we have, what do you think? Our orders are just to be treated as something useless?
My lord, this is with utmost respect, my lord, and something, only because
There's
of,
nothing respectful about
no, my lord,
trying to ask for adjournment.
no, I could
We
have
said
done
that
it, my
no
lord.
adjournment will be
My lord,
given.
I could have done it tomorrow.
Do it tomorrow if you want.
My lord,
That's done.
tomorrow.
No,
But
otherwise-
tomorrow and day
otherwise-
after tomorrow, your lordship will excuse me.
Day after tomorrow is, no, tomorrow will be. You see, you have to give some sanctity to our orders.
Yes, my lord.
Some sanctity has to be given to our orders. On 27/11 also, it was on your prayer for adjournment that we have allowed. Then again, on 27/10 also, again it was on your prayer.
Yes, sir. I respect
Then
the man.
again on 1st January. And then we had said that no further adjournment. You want me to read other orders also? There are others.
This is my lord, your lordship's order.
You cannot,
Your lordship.
stretch the indulgence that we have given to such an extent that you make a mockery of our orders.
Tomorrow and lordship, I will ask because
No, tomorrow.
I'll not cite the reason why tomorrow and day after tomorrow.
We'll appoint someone. You can go to the Supreme Court and.
No, my lord, even if your lordship appoints the assistants for the court, I can still argue. It's not that I can't argue. Your lordship can bar me from arguing. my lord.
We're not stopping you from arguing.
No.
We'll appoint and we'll list it for tomorrow. If you want to help that legally,
My lord, sometimes we don't cite our personal reasons before this court for seeking accommodation. Otherwise, your lordship has seen I have never sought accommodation from any court or as a. But this,
You want me to read these orders?
my lord, your lordship will say this is a criminal appeal. It has to be hard on merit. My lord, your lordship will accommodate me, and then this person is jailed. No prejudicial cause to the prosecution if the matter is hard on any other day, other than day and tomorrow after, my lord. I can only pray before your lordship. It's up to your lordship. I will not argue on it, man.
We cannot allow.
I fully appreciate your lordship, sir.
Appreciate it.
No, my lord, I cannot say my personal reason for not.
Giving lip service.
No, my lord. I am only making a submission with from sincerity that I'll argue this matter on Monday next.
Monday, I'm not here. Monday, neither is my brother here.
It can be listed before any other bench, my lord. I have no objection.
Enough for adjournment. I know.
No, my lord. No, your lordship will record my submission, my lord.
Yeah,
The first item.
Our last date, we are
Last
giving
date I
you-
was not there, my lord. Last day I was unlucky because last day I was also not there, my lord. That's why I was who will seek for an accommodation. It's better, my lord, I finish up my old cases and concentrate on other new cases, my lord, instead of keeping matters pending.
That's why this matter has been kept pending since 2022.
But I have
This
been
appeal is from
initially
2022. Criminal appeal 2022, 18 of 2022.
Initially, I was not a counsel, my lord. Initially, some other was there. I have been engaged, my lord, later on also. Good.
Your name has appeared on 25/4,
Yes, sir.
25. After that, 2, 3, 4, 5, 6, 7, 8. Not the way. Mr. B.D. Kowar, learned senior counsel for the appeal. Praise for adjournment on the ground that he is not prepared for this case. This court, while order dated 6/1/2026, had adjourned the matter on the prayer made on behalf of Mr. B.D. Kowar and had observed that no further adjournment would be given today. It was further stated that in the event of any adjournment being asked for, this court may appoint a legal aid counsel / amicus curiae for disposal of the case on the basis of the paper book already prepared. Let's start. This case has been pending since the year 2022. And the matter has been adjourned time and again without any attempt to really dispose of the appeal. We are of the view that
ৰাতি গাটোৱে ভাল লাগিছে মই টোপনি ক্ষতি হলে বহুত বেয়া লাগে কিবা কাৰণে চিকমতাত কৰিলো আৰু বিয়া এখন আছিল কালিলৈ মানে জুনিয়ৰ বিয়া ক'ত আহিম
And another thing, Mr. Kowal,
Yes, madam.
your junior, when she had appeared prior to the recess,
Yes, sir.
he had said that please, for the time being, adjourn the matter as he's on his legs in court number 1.
Well, I can
She did not ask
Yes.
for adjournment.
Well, only I have sought, madam, because
Sorry, why didn't you tell us then?
well,
So we had other things to do.
well, problem was that I said not in the best of state. If your lordship wants that I can start some part today, the rest your lordship can hear it on Monday. Your lordship can keep it parted.
No, we'll hear you only. We don't need to hear the other side. We'll hear other side. We can hear another day. We can hear you. We can hear them tomorrow. If you finish today, it's enough. You will not take long.
No, I have to read the
You
evidence.
read whatever you read. We'll sit here till 6, 7 o'clock also you want.
No, my lord, I will be not in a position to argue till 7.
No, but then it doesn't mean that
Your lordship
because they've got a-
your lordship will cut short of that. Your lordship, for taking my adjournment, your lordship will impose a cost on me to pay to the legal aid committee.
No, it's not about money.
Some the via media your lordship will have to say
You
that.
see, Mr. Counsel, your
Because
junior,
I have also no,
junior could have easily told us.
no, she has no instruction to submit.
You should have given her.
No, my lord, it
The
was on.
instruction that was given by you to her was
Yes.
to adjourn the matter
Yes.
for the time being.
Yes.
That's why we waited. for-
Yes, that was there, but now I'm not feeling in the best of spirit. That's why I'm seeking a.
No one. You see,
3:45,
we
but
are
I'm not
also
feeling well.
tired, but then we have got a duty to do. That's
Yes.
what we're doing.
Well, I have, as an officer of the court, I have a duty, my lord. Your lordship will appreciate. Normally, I don't seek time on personal inconvenience or any other difficulty. Most of the time I'm here before your lordship. Maybe this case, but the order sheet does not reflect properly on my taking adjournment or why it has been adjourned. My lord, I leave it to your lordships. Your lordship will take the call, my lord. I'll not.
You can start. We'll finish it off then. You can
Well,
start.
today it's difficult on my part. I'm not feeling quite well, my lord.
Right.
Yeah.
What have I said?
On a lighter vein, your lordship can get me examined by a medical doctor. My lord. I'm not feeling well. Pressure is fluctuating. And I hope.
19th of all those were fixed Romania. Right? Well, 20th, but fix something. It is a problem. List this matter. On 2020.
20th of February.
For final disposal. As at serial number 1 in the hearing form.
I'm obliged, madam.
No adjournment will be given on the set date. And if required, a legal aid counsel may be appointed for the appearance of the city. Yes, yes.